The High Court. In this video, we are going to learn about the High Courts of India. So, first of all, we would learn about the composition of the High Court, the qualification and appointment of the judges, independence of the judiciary, original, appellate, and revised jurisdiction. Also, we would learn about the judicial review, the court of record, and the enforcement of the fundamental rights. So, first of all, let's learn about the qualifications of a High Court judge. A judge of the High Court must be a citizen of India and he should have held a judicial office in India for at least 10 years, or he should have been an advocate of a high court for at least 10 years, or he must be, in the opinion of the president, a distinguished jurist. Appointment. The President of India appoints the Chief Justice of the High Courts in consultation with the Chief Justice of the Supreme Court and the Governor of the concerned state. Other judges are appointed in the same manner, except that in their case, the Chief Justice of the High Court will be consulted too. The Chief Justice of India will consult two senior-most judges of the Supreme Court. The President may appoint additional judges if in the case of temporary increase in the work of a High Court. Independence of the judiciary. So, the independence and impartiality of the High Court is ensured by following measures. The President appoints the judges of the High Courts after consultation with the Chief Justice of India. A judge retires at the age of 62 years. Please keep in mind, the High Court judge retires at the age of 62 years, whereas the judges of the Supreme Court retires at the age of 65 years. So, a High Court judge retires at the age of 62 years. He can be removed by the President only on the grounds of proved misbehavior or incapacity. The salaries and allowance of the judges are charged on the Consolidated Fund of India and cannot be put to voting in the Parliament. Their salaries can only be reduced during the period of financial emergency. No practice after retirement. After retirement, judges of the High Courts cannot practice in any court or tribunal of India except the Supreme Court and the other High Courts. This means the retired High Court judge cannot practice in the lower courts and the same High Court from which he has retired. For example, if a High Court judge retired from the Allahabad High Court, he cannot practice in Allahabad High Court after the retirement. He can practice in other High Courts like Patna High Court, Madras High Court, and any other High Courts except Allahabad High Court. And he can also practice in the Supreme Court of India. But in any case, he cannot practice in any lower courts like the subordinate courts or the district court in any part of the India. No discussion regarding the conduct of the judges in the legislature. No discussion should take place in the Parliament regarding the conduct of the judges except there is a motion for his removal. The High Court can punish a person for the contempt of court if it tries to lower the authority and honor of the court. Now move ahead to the jurisdiction of the High Court. Original jurisdiction. Original jurisdiction means those cases in which the High Court can hear and decide in the first instance. If you have that matters, you can directly approach the High Court. You don't need to go to the district or subordinate court at the first. So, High Court has ordinal jurisdiction over the following cases. The cases related to wills, divorce, marriage, admiralty, company law, and contempt of court. It can be taken up by the High Court directly. The constitutional cases could be taken up under the ordinal jurisdiction of the High Court. Every court has a power to interpret the Constitution, and this power is known as the power of judicial review. The High Court has the power to issue writs for the enforcement of the fundamental rights. Election petitions challenging the elections of the Member of Parliament or the members of the state legislature or other local bodies can be directly tried by the High Court of the concerned state. It has the ordinal jurisdiction over cases related to land revenue as well. Appellate jurisdiction. The High Court has the power to accept appeals against the decision of the district courts in civil as well as criminal cases. In fact, the High Court hears appeal against the decision of the lower or subordinate courts. Revised jurisdiction. The High Court may call for the record of any case which has been decided by a subordinate court. If the High Court feels that the subordinate court has exercised jurisdiction not vested in it or has acted with gross irregularity, it may review the case and take appropriate action on it. Now, let's talk about the power of judicial review. The High Court has the power of judicial review like the Supreme Court. If the High Court finds that a particular law issued by the state legislature or an executive order is going against any provision of the Constitution, it can declare that particular law or that order null and void. Court of record. The High Court is called a court of record because of the following reasons. All its judgment and orders are kept as records. These can be produced in any court as precedents. The law laid by the High Court is binding on all subordinate courts and administrative tribunals in the state. If a person disobeys the order of the court, the High Court can punish him on the ground of contempt of itself. Now, the most important task of the High Court: enforcement of fundamental rights. A writ is a form of written command or a document commanding a particular person or official to act or not to act in a particular way. There are various kinds of writ or orders issued by the High Court and the Supreme Court as well. And the writs are of five types: habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Now I tell you a fact that the Supreme Court can issue writs under Article 32 in the cases that is related to the violation of fundamental rights only. So the Supreme Court can issue writs in the matter which is related to the fundamental rights only. Whereas the High Courts issue writs under Article 226, and it has a wider power because High Court can issue writs in fundamental rights and other matters as well. So we can say that the power of issuing writ of High Courts is wider than that of Supreme Court. Habeas corpus. Habeas corpus is a Latin word meaning you may have the body. The High Court can issue a writ of habeas corpus to a person who has illegally detained another person in custody and command him or her to bring the détenu into the court. And if it is proved that the détenu has wrongly been detained, then he will be at once and unconditionally released. Mandamus. The Latin word mandamus means we command. The High Courts can issue this writ to compel an inferior court or an official or an individual to perform its or his duties. Prohibition. A writ of prohibition is issued to prevent an inferior court from hearing a matter beyond its jurisdiction. Certiorari. The term certiorari means to be informed about what is going on. By this writ, the lower court is instructed to hand over the record of a particular case to the higher court. Quo warranto. The term quo warranto means by what warrant or by what authority. This writ is issued against a person who has wrongly occupied an office. If the court finds that the person is holding the office illegally, it will order him to vacate the office. That's it in this session. Thank you so much for watching. Have a great day.